Everybody, it's a lovely sunny day here in Cape Town, although you're having some rain in KwaZulu-Natal, but I believe Cape Town's in for some more rain coming tomorrow and especially on Saturday. So I'd like to kick off by extending a very warm welcome to all the clients of Business Accounting Network that are joining us this morning, as well as the clients of Justine Del Monte and Associates, and all the business owners and entrepreneurs who are also joining us this morning. And might I say to everybody, happy Halloween. So my name is Monique Charland, and I'm the CEO and the founder of the national franchise company Business Accounting Network, or better known as BAN. Now, as business owners, irrespective of how small some of our businesses might be, we are already overwhelmed by the sheer volume of laws and regulations that govern literally our everyday lives. And there is nothing more daunting as a business owner than the do's and the don'ts around labor law. So our presenter today is Justine Del Monte of Justine Del Monte and Associates. She's an admitted attorney to the High Court since 2002, and who has been a strategic alliance band partner for many years. And Justine and I have worked together over probably the last 5, 6, 7 years. Justine has over 15 years experience in career law and represents both employers as well as employees. Just a little housekeeping before we get started. We would obviously love to hear from you. Shane has already shown you how you can address questions on the webinar. So if you do have any questions during Justine's presentation, if you could please just type them in the question box as they come to your mind on the control panel, and then Justine will address those questions at the end of the webinar. Okay, so without any further ado, we'll cross over to our presenter today, Justine Del Monte. Welcome, Justine.
Thank you for your time this morning. I'd just like to give you a little bit of an overview of what we're going to be chatting about today, as it's titled Labour Relations 101. So it's not going to be an in-depth discussion on all of the topics. I want to give you an overview of those things that I am seeing in the CCMA a lot, things that our clients are asking us, queries that are coming up more and more frequently, so that you can get a better understanding and an idea of what is going on out there. And just to give you a little bit of information so that if something happens, a light bulb goes off and you know I need to contact someone, or this is something that I need to be concerned about. All right, so the first topic is a hot topic, and that is dismissals. Just a broad overview of what we're going to be doing today. And the first one is going to be dismissals. When can I dismiss and how do I go about it? It is a very broad topic, so I'm just going to be taking you through the basics so that you have an idea of that. So the first thing is the different types of dismissals. In our employment law, there are 3 broad categories: misconduct, capacity, which is either poor performance or ill health, and operational requirements, which is what we all know as retrenchments. Now, the important thing as employers is to remember that the onus is on the employer to prove that the dismissal was fair. And that proof is in proving that there was a substantively and procedurally fair dismissal. Substantive fairness is the reason for dismissal, procedural fairness is the process. And what one then has to do is you have to match the reason with the process. As you can see on the slide, misconduct, there's disciplinary action that is followed. Capacity, if it's for poor performance, there's performance counseling. If it's for ill health, there's an incapacity investigation. And where it's operational requirements or retrenchment, there is a consultation process. So if you match the reason with the process, that's the first part of winning the battle if you call to the CCMA. So if we look at the actual processes that we need to follow, let's go into that in a bit more detail. All right, so for misconduct, as I said, there's a disciplinary process that needs to be followed. And I've just broken it down in a slide form, a flow diagram to take you through it. All right, so the first question is the employee involved in misconduct? If no, no further action. If yes, have there been prior warnings? Or is it a first offence? If it's not a first offence, you would go down to a disciplinary hearing. If it is a first offence, or if there have been no warnings issued, you would then issue a warning. All right. And if you look on the right-hand side of that slide, you'll see the words audi ultram partem. That means always listen to the other side. So that's the second key takeaway from this. Procedural and substantive fairness is the first one. The second one is always hear what the other side has had to say in any situation, even if you're issuing a warning. And it's a very simple process. This is what's happened, X, Y, and Z. What do you have to say for yourself? What is your explanation? Consider it, and then issue the warning. All right. Going from that, if this is an individual who has more than one warning, or if it's a very serious offense, you would go to a disciplinary hearing. Now, at the disciplinary hearing, you are going to hear evidence, and you are then going to have to decide whether the person is guilty or not guilty of the offense. If they are guilty, you will then have to decide on an appropriate sanction. All right? And the question then often is dismissal appropriate or is it inappropriate? If dismissal is appropriate, that's what we're going to be looking at now, how to decide that. But if you're not going to dismiss, one can always issue a warning. One can, give someone unpaid suspension as a potential sanction. So looking at the questions, so the questions in the dotted box on the right-hand side, that is when you're looking at whether the person's guilty or not. All right. So for misconduct instances, is a person guilty or not guilty? The first question you need to look at is, did the employer contravene a rule or standard regulation of conduct or of relevance in the workplace? If no, they're not guilty. If yes, the next question is, was the rule or standard reasonable? If no, if the rule or standard is not reasonable, obviously one can't find the individual guilty. If it is a reasonable standard, the next question is, were they aware of it, or could they reasonably have been expected to be aware of it? If the answer there is yes, the next question is, has it been consistently applied by the employer? Because it's unfair to dismiss or find someone guilty of an offense where certain individuals have been left to skate and others haven't. So there has to be consistency. And then the final question is dismissal an appropriate sanction? Now there, when determining whether it's appropriate or not, you would look at the mitigating and aggravating factors, which is length of service, whether there was intent, was it negligent, whether the individual is employed in a position of trust, those kind of things. But that is really just the broad overview of how to deal with misconduct. So it's the flow diagram, the first one. Have they been involved? That's the process. And then when you get to deciding whether or not they're guilty, those are the questions one asks. All right, so that's misconduct in a nutshell. Now looking at incapacity, and as I said previously, incapacity can either be poor performance, they're not doing the job, or it could be ill health. They're incapable of doing the job because they've been injured or because they are ill, something like that. So the first question one asks oneself is the employee able to perform the duties and functions for which they were employed? If the answer is no, one then looks at what is the extent, right? Is it long-term or is it going to be a short-term problem, all right? That's what one moves down to. You'll see it along the top up with the dotted line. I've got incapacity and disability and medical boarding. Those are things that one can consider when looking at the extent. If the person is clearly unable to do the work and are disabled or medically, potentially one could look at medically boarding them. So medical boarding is an application that one would make to your insurance providers if that is a possibility in terms of your insurance policies. And if one is able to get an employee medically boarded, the employment relation will then cease and you don't have to do anything further. So that's something to consider. It's obviously also beneficial to the employee because they will be receiving some sort of a benefit rather than being dismissed. All right, but that's a question to ask when you start this kind of process. Going back to the extent, one looks at, is it long-term or is it going to be short-term? If it's short-term, then there's an expectation on the employer to make allowances for the individual. If it's going to be long-term, then there are certain questions that the employer then needs to ask, because you cannot be expected to carry an employee who is not able to perform the functions for which they were employed. All right. So when it comes to long-term, the first question you are expected to ask is, are you able to adapt the working environment or the circumstances around the employee? All right. That is the first question. If you are, you're expected to do so. If you aren't able to adapt the work environment around them, can you, the next question is, are you able to adapt the duties and functions that they perform? And the courts have always said that you need to look at whether or not you can adapt the working environment first before you look at adapting the duties, because there's the courts view adapting the duties first as an infringement on the employee's dignity. So it's always working environment, can that be changed? If you look at the dotted block on the right there, I've got unjustifiable or if it's a hardship. So yes, the employer is expected to adapt the working environment, but only to a certain extent. If that working environment or adapting that is going to cause the employer to suffer an unjustifiable cost or a hardship, or is going to affect business in a negative way, then you aren't expected to do so. All right. So if you can adapt the duties and the functions, you must do so. If you cannot, the next question is there another position into which I can move them? And that's fine. If the position is a lower paid position, they are then expected to accept the lower rate. You're not expected to keep them on at their current rate. But that's the next step. And then only if you've answered no to all of those questions can you look at dismissing the individual for incapacity, because then they are incapacitated and you can't fit them in to the workplace in any capacity. All right, so that's ill health in a nutshell. We go to the next one. We're looking at poor performance. All right, so remember, performance and incapacity is divided into performance and capacity to perform due to health. All right, so here you have someone who may not be performing their functions. Hopefully you've got a probation period in your employment contract, because then dismissing someone during that probation period for poor performance is much easier, even though you are still expected to follow this process to a certain extent. So the first question is, in the process, the actual procedural side of things is, are they performing satisfactorily? And if not, have you had informal counseling with them? Which is verbal instruction, verbal counseling, day to day, this is, you aren't doing this correctly, I want you to do it this way. That's informal counseling. All right. If that hasn't borne any results, the next question is, now we need to look at formal counseling, and has that resulted in any improvement? And only if the formal counseling hasn't resulted in improvement do you then go to a performance hearing. And remember that, as I said, the second takeaway is audi alteram partem, always listen to the other side. So if the person hasn't been performing and you have been counseling them, you are still expected to give them a final opportunity to make representations as to why their employment shouldn't be terminated before you actually have the dismissal. All right, and then at that performance hearing, you as the decision maker will have to answer a couple of questions. All right, and the questions are, did the employee fail to meet the performance standards? If yes, was the employee aware, or could the employee reasonably have expected to be aware of this required standard? If yes, was the employee given a fair opportunity to meet the required standard? And if yes, is dismissal an appropriate sanction? All right, so those are the questions. And the questions that I have in these slides are the questions that a commissioner at the CCMA is expected to answer. All right, And that's what they'll be applying their mind to in determining whether the dismissal was fair or not. All right, or whether the individual is guilty. So that is performance. So did they fail to meet the standard? Were they aware of the standard? Were they given a fair opportunity to meet it? And then one can dismiss. Because you have shown that no matter how much counseling you give the individual, they are not going to improve. All right, the last form of dismissal are operational requirements or retrenchments. Now this slide, the next couple of slides, are going to be quite dense because I've taken the sections of the Act out. It's the only process that actually forms part of the Labour Relations Act, the actual sections of the Act, and I want to take you through those. All right, so assume the first thing and key is that as soon as an employer contemplates retrenching employees, it must start consulting and it must start complying with Section 189 of the Labour Relations Act. So therein is the first important clue. As soon as it's contemplated, you have to start consulting. So how you announce it to the staff, what you're saying to your employees when you're considering potentially restructuring or whatever the case may be. It's very important because you don't want to create the impression that you are contemplating it without actually initiating the process, because that in itself sets you up for a potential claim of unfair dismissal. So what are operational requirements? There are requirements based on the economical, technological, structural, or similar needs of the employer. All right? As you can see, very broad. And our courts have also found that, and I often get this question from employers, have found that you can retrench in order to make a profit. A lot of employers think that you have to be facing liquidation in order to start retrenching. That's not the case. So long as it's, remember, fair reason, fair process, so long as it's a justifiable reason and doing good business and making a profit is regarded as being a good enough reason. So long as you can justify it, you can follow this process. All right. So what is that process? So as soon as you contemplate, remember to contemplate, you're thinking about it, dismissing one or more employee based on your operational requirements, you have to start consulting. Important to remember, it's not a negotiation process, it's a consultation process. So you listen to what your employees have to say, you consider it, and then you give feedback as to whether it's acceptable or not. All right, consultation, open mind discussion, but not a negotiation, which means they don't have to agree, or you don't have to agree. So who do you have to consult with? And the Act sets it out quite clearly. If there's a collective agreement, you have to consult with the parties in the collective agreement. If there isn't a collective agreement, but there is a workplace forum, you have to consult with those. Very few employers that I deal with actually have workplace forums at this stage. If there is no workplace forum, then you look at unions. If your workforce is unionized, for those members who are members and are going to be affected, you're obliged to consult with the union on their behalf. Those employees who are not members of that union, you consult with individuals directly, all right, which is the last point there. Something to bear in mind is for staff who are not unionized, because generally one either has unionized staff or not unionized staff when you're doing a 189 process. You can ask the individuals, if it's a large group of individuals, to elect a spokesperson. So instead of meeting with a big group of employees each time during the consultation process, you can have someone elected or a panel elected to speak on behalf of those individuals, sort of them forming their own little union. All right, even though it's not recognized. So those are the parties you have to consult with. Then, when consulting, you must attempt to reach consensus on measures, one, to avoid dismissals or minimize the number of dismissals, to change the timing of the dismissals, to mitigate the adverse effects of the dismissals, the method for selecting the employees who are going to be dismissed, and the severance pay. So those are the key takeaways for that process, which is what are we trying to reach agreement on? Important to note, even in the Act itself, it says must attempt to reach consensus. It doesn't say must reach consensus. So once again, an indication that it's a consultation process. It is not, you do not have to reach agreement before you can dismiss. All right, so now we know who we have to consult with, and we know what the aim of the consultation is. Next question then is, how do we go about the consultation process? So the Act's very clear, gives us good guidance. It says the employer must disclose in writing to the other consulting parties the relevant information, including but not limited to. All right, so looking at this, what is it? Always bear in mind, what is the purpose of this document that you're going to be issuing? And the common term for it is an invitation to consult. What is the purpose of issuing this document? The purpose is to put forward our proposals, the company's proposals, and then give the participating parties enough information so that we can engage effectively on those issues. We often see invitations to consult that are issued that really just regurgitate this section of the Act. And it says the reasons for the proposed dismissals, it'll just say financial. There'll be no information given to the individuals so that they can interrogate that and engage in consultation. Or it'll just cite their headings and say this will be discussed with you. Those kinds of invitations to consult set up the employer for failure, because the CCMA and the labour courts take a very dim view of issuing a document like that, because the employer is in control of all the information, and it's your obligation as employer to disclose. You don't have to disclose everything. Obviously, there's certain pieces of information that are confidential, but you need to be able to demonstrate that you're giving the individuals information with the view of participating in a constructive process. All right, so let's go through those. The first thing is the reasons for the proposed dismissals. Why are we looking at retrenching? Next, alternatives that the employer considered before proposing the retrenchments and reasons for rejecting each of those alternatives. Now, this can be divided into two. The first thing is, what have I done to try and avoid it? What are the alternatives I've looked at to try and avoid this consultation process as a whole? So, for example, if it's financial, what have I done? Have I looked at salary, not paying bonuses? Have I looked at cutting rental costs, looking for cheaper premises? Have I looked at all of our other spends and being able to reduce those? So, for example, instead of everyone flying business class, are we now flying economy? All of those things, and you put that into the invitation to consult, because these are the things we've done to try and avoid being here. Also, when looking at alternatives, it comes in later is, if you are potentially going to be retrenched, what alternative positions do I have for you within the organization that I can offer to you, but that would still meet my requirements of reducing costs? So, for example, there may be lower level vacancies where I need to fill that vacancy because it's an important position, but the salary is far less. You could offer that as an alternative to retrenchment. So those are the two alternatives, and employers often miss the first one, which is, what have we done to try and avoid it? And secondly, then, what alternatives can we offer you prior to dismissing? All right. C, the number of employees likely to be affected and the categories, because the unions need to know who is going to be affected and who they're going to be consulting on behalf of. D, the proposed method for selecting which employees are going to be dismissed. Now, this is a contentious issue. Everyone says LIFO. It doesn't necessarily have to be LIFO. Last in, first out is the easiest way of doing it. But your workforce may be such that there may be individuals with experience and skills who've joined you later but that you want to retain, but are critical. These individuals are critical for your business going forward. So those are the selection criteria that you would look at. You need to look at what is going to be necessary for your business to continue, but you must be able to apply those criteria that you propose in an objective manner and fairly. So, for example, employers often make the mistake of saying for performance or warnings or work record is used as a selection criteria, which is possible, but is extremely tricky because you then have to go into the history of the individual's performance and show objectively that they haven't been performing, that they have been performance managed and their performance measured against all the other individuals who you're going to be looking at for potential retrenchment. Theirs is far worse on an objective scale, and that they've been given a fair opportunity to improve. And that becomes a very difficult exercise to substantiate in court. So my suggestion is always look at if there are critical skills you need to retain, those are easily defendable. LIFO obviously is the most easy because it's last in, first out, and you can apply that across the board. All right. Next, the time when or the period during which the dismissals are likely to take effect. That's fairly simple. The severance pay proposed. How much are you proposing paying individuals who are going to be retrenched? The basic minimum is 1 week per completed year of service. Is that what you're going to be offering? Are you going to be offering a bit more? Are you going to be, that is something that you actually need to engage with individuals on. G, any assistance that the employer proposes to offer to the employees that are likely to be dismissed. And please don't say we will give you a UI-19 and a certificate of service. That's not assistance because you're required to do that in law in any event. So is there any other assistance? So for example, releasing the individuals from working their notice period so they can go and look for jobs, allowing them to attend interviews while they're still employed. Those are the kind of things that we're looking at here. And the possibility of future re-employment for those who are dismissed. If a position comes up again, if circumstances change, are you prepared to take these individuals back? Would you be expecting them to go through a recruitment process again? How do you propose dealing with that in the future? All of that goes into your invitation to consult. The letter that you give to the individuals who are going to be affected, they're going to be provided with all of this information. And then you start meeting with them and engaging on these issues. And as I said, you don't have to reach agreement. You must, however, show that you've considered what they've had to say and you've given them reasons as to why you may not agree with them and why you're not accepting their proposal. That is all that's expected. Okay. So there we go. As I've said, the Act requires you to allow the other consulting party to make representations, and you must consider and respond to those representations. And if you don't agree, you must give reasons for disagreeing. And when it comes to the selection criteria that we mentioned earlier, they must either be agreed to by the parties, or if it's not agreed by the parties, they have to be fair and objective, which speaks to what I was saying about the performance, using performance of disciplinary records as a selection criteria, which is risky ground. All right. As you can see, all of this, these sections are taken straight from the Act. So they tell you exactly what you have to do. All right. So when it comes to consultations, they divided, the retrenchment process is divided between what the law regards as small retrenchments versus mass retrenchments. And there's a distinction. There's a Section 189 process, and Section 189 applies to all retrenchments, which is the process that we've just discussed. Then for mass retrenchments, there's an additional process that has to be followed. And there is a prescribed consultation period of 60 days. You cannot give notice of dismissal within that 60-day period. All right? And that 60-day period starts from when you issue the invitation to consult, and then it runs for 60 days. All right, so the question then is, Well, how do I know whether it applies to me or not? And here it is. It applies to you if you employ more than 50 and you're looking at contemplating retrenching 10 and when you employ less than 200. Or you employ more than 50 and you're contemplating retrenching 20, where you employ between 201 and 300. So that's the formula, all right? So 1, do you employ more than 50? If you do, potentially you fall into this. And then you look at, all right, exactly how many am I contemplating retrenching? What is the ratio? And do I fall into this? If I fall into this process, I have to consult for 60 days, which means I need to understand that I'm going to have a wage bill that I'm carrying for another 60 days. All right. These figures are determined over a 12-month period. All right. So what it means is I look at how many am I contemplating now, plus how many have I retrenched in the previous 12 months. So for example, I am contemplating, I employ 205 employees, and I'm contemplating retrenching 10 now, but in the preceding 12 months, I've already retrenched 15. Then it will be a 189A process because I fall within the 20 where it employs between 201 and 300, and it's what I'm contemplating now, plus what I've retrenched in the previous 12 months. So it's important to remember that because it comes with that additional wage bill of 2 months. All right, so that is the dismissals and when you can dismiss and how you should be doing it. Please understand that it was a very quick, very broad overview. Just to give you an idea, if you are faced with this in practice, it's always best to get advice on how to do it because it is fairly simple to get a dismissal right and you do not have to end up in the CCMA. And while we're speaking about that, Shane, I was wondering if you could please ask our participants to give us an indication of how many of them have actually been involved in the CCMA processes.
Yeah, so results of the first poll, we have got the majority, 65%. So it's practically a 2/3 majority have selected no, only 35% yes.
Wow.
Yeah, back to you. Thanks, Justine.
Wow, that's great. A great outcome. Everyone seems to be doing the right thing then, which is always awesome. But it's good to know now that you've got the overview as to for those few that have been to the CCMA, what to improve on. Okay, the next topic is constructive dismissal, fact or fiction, and that we are seeing a lot of our clients freak out at the idea of constructive dismissals. Employees are often banding about the term constructive dismissal. Oh, I'm being constructively dismissed, and it strikes fear into the hearts of the employers. And that's why I wanted to just touch on that very briefly. So what is a constructive dismissal? Because both employers and employees don't seem to understand what it is. And that is where an employee resigns because the employer has made continued employment intolerable. All right. So employees saying, oh, I've been constructively dismissed when you've actually terminated the employment, that is not a constructive dismissal. The employee has to resign. All right. And it's important to bear this in mind because it switches the onus. As we said at the beginning, when an employer dismisses, the employer bears the onus of proving substantive and procedural fairness. When an employee resigns and claims constructive dismissal, the onus is on the employee to prove that the employer made their working conditions intolerable. So that's the first distinction. Also important to bear in mind is that there must be some causal connection between the employer's conduct and the circumstances that induced the employee to resign. All right, so the employer must have done something to cause it. It cannot just be, oh, the workplace is not a great environment, oh, this is not what I wanted, something like that. The employer there must be that causal connection. As I said, the employee bears the onus to prove that the employer made employment intolerable. and it is an objective test. So if you have an overly sensitive employee who takes offense to everything and then wants to refer constructive dismissal and say, oh, well, you made the working conditions intolerable, that's not going to apply. It is an objective test. Is it anyone in that situation, would they have reasonably reacted in the same manner? All right. And where an employee could reasonably have lodged a grievance, which would have dealt with the unhappiness in the workplace, and they don't do so, they are going to have difficulty in persuading the arbitrator that they had no option. Because not only do you have to show that your working conditions were made intolerable, but you have to show that you had no alternative but to resign. So there is some onus on the employee, not huge, but there is some sort of requirement on the employee to show that I tried to address this with my employer. You know, if someone resigns and claims constructive dismissal for some reason that they said you upset them, and you were completely unaware of what you were doing, that is not going to be found in their favor either. The employee has to try and address the issue with the employer. If the employer just ignores that, well, then it becomes difficult for the employer to justify the dismissal. All right. And something else for employers to bear in mind is that a constructive dismissal is not necessarily unfair. Okay? So the employee may be able to show that their working conditions were intolerable to the point that they had no option but to leave. But the employer may still be able to prove that it was fair, that their conduct was fair. Right? So, for example, the case we often see, you are performance managing someone, and that person leaves, resigns in the face of that and says, oh, well, their working conditions were made intolerable. Yes, maybe it was intolerable, but you were acting fairly as the employer because you are entitled to performance management, to performance manage someone to get them to the point where they are going to be able to deliver on what you are paying them for. Or another example is where, for example, the business isn't doing well, and it's not through the employer's fault, and a client's just not paid for a consignment that's been sent to them, and you're cash strapped at the moment, and the employee then resigns and says, well, it's intolerable because they're getting paid late, and off they go. If you can show that it wasn't your fault and you were putting measures in place to address it, well, then you weren't acting unfairly, even though the individual's circumstances may have been intolerable at the workplace. So that's also important to bear in mind. And where an employee resigns rather than facing disciplinary hearing, it will generally not be held to not have been a constructive dismissal. And we often see that. Or I'm being constructively dismissed because I'm being performance managed. I'm being constructively dismissed because I'm late every day and I'm now being sanctioned for that. We're seeing that more and more and more. It's become a huge issue, but it's important to bear in mind that throwing out constructive dismissal is a threat. It's a threat. It's not something to be overly concerned about unless one of these issues sparks a concern for you that we've discussed. All right. Mutual termination of employment is another thing that we are dealing with a lot. And that is where the parties agree to terminate the employment relationship. You know, it may not be working out for either party, and the parties decide, well, we're going to call it quits. Or you give the option, an employee's committed misconduct, but you're not entirely comfortable with all of the evidence that you have, and you think that, well, if I dismiss this individual, it may not stand up in the CCMA if I'm called to answer for it. So you then enter into an agreement with them whereby they exit the business. All right. There are it's perfectly permissible to enter into such an agreement. And an agreement of this nature is binding if you follow certain requirements. So the first thing is the agreement must be put in writing. It has to be put in writing to avoid any sort of dispute later on as to what the terms were promised. So what terms were promised to the individual in order to get them to sign the agreement and to exit by mutual consent. Secondly, and this is a constitutional court case, I've cited it there just so that you have it as a reference so that you know what I'm saying is correct, is that you can enter into an agreement terminating someone's employment and preventing them from challenging that termination. And that agreement will stand up in court, as it did in this particular instance that's cited there, the Beckesser case, where you are putting the individual into a position that is better than what they would have been in had they been dismissed. All right? So you need to give them something more than what they would have been entitled to were they dismissed. So, for example, the instance that I mentioned, someone's facing a disciplinary hearing and they could potentially be dismissed, but you know the evidence is a bit iffy, or the witnesses, you're not convinced that they're going to stand up, and you'd rather enter into an agreement and get the person out. So the question is, if I was to dismiss this person, what would they get in law? Well, they may or may not get their notice period, they would get their leave pay, and they'd get their salary up to the date of dismissal. So what am I going to give them in addition to that, so that they can sign that agreement in full and final settlement? So you look at what I have to give them in law if I was to dismiss them, and you add something to that in exchange for them signing the agreement in full and final settlement, and then that agreement is binding. All right. And then if the employer wants to challenge the termination of their employment following that agreement, then they're going to have to prove that the agreement was signed under duress, that there was a threat. And that's difficult to prove if your agreement is drafted properly and if the agreement is presented correctly to the individual at the time. So if you are contemplating paying someone to go, and we're seeing more and more of it because it cuts the process right there and then, and there is no litigation, time-consuming litigation afterwards, then consider putting in a little bit of extra money, or, for example, a favorable letter of reference. That's something that you're not required to give in law. You only have to give a certificate of service. So if you give them a favorable letter of reference, or perhaps allow them to leave without having to work out their notice period, something like that, get a bit creative, then that agreement is concluded and that's the end of that, done and dusted, and you won't have issues with it. All right, the next topic is also something we're seeing a lot of. And Shane, if I can call on you to run another poll for me, please. I'm very curious just to know how many of our participants actually make use of fixed-term contracts in their workspaces.
So there you go. Results of that second poll. Does your employer or business make use of fixed-term employment contracts? We've again got a 2/3 majority, this time opting for yes. So 68% have selected yes, the other 32%
Wonderful.
no. Back to you, Justine. Thanks.
All right. Thanks so much. So to the 68%, you're going to want to listen to this carefully. To the other side, bear this in mind if you are going to be contemplating entering into fixed-term contract. So we often get the question, you know, I'm using a fixed-term contract. I've been there the individual's been with me for 4 to 5 months. They're now permanently employed. We often get that question. And there's a new section, well, it's relatively new still. Employers are grappling with it, with this whole scenario of when do people become permanently employed if they've been on a fixed-term contract. It's quite a complicated section in the Act, so I've struggled with it, so I've kind of done a mind map of it just to explain it a little bit more easily. All right, so this came through with the last round of amendments 2 or 3 years ago. And it's to address issues surrounding fixed-term contracts, because employers are using them and are rolling fixed-term contracts to prevent individuals from gaining the benefits of permanent employment. So the first to answer the question, when am I a permanent employee? The answer is never. If you're on a fixed term contract, you never become a permanent employee. All right? You do not become a permanent employee, but you will be presumed to be permanently employed. In other words, you'll be treated as if you are permanently employed under certain circumstances. And the circumstances are important for employers to bear in mind because it still leaves room for fixed-term employment, and fixed-term employment is still critical. Because if you had to employ people permanently and then retrench them every single time that circumstances changed, everybody would be bankrupt. So yes, there's still a need for fixed-term employment contracts, and it is still possible to have fixed-term employment contracts without this presumption of permanent employment if you are using the contract for what it was genuinely intended for. All right. So let us look at breaking this down for you so that it's a bit more manageable. So if you look on the left, you'll see the questions. On the right, you'll see the add-ons to those questions. So the first question is it a fixed-term contract? What is a fixed-term contract? A fixed-term contract is a contract that terminates on the occurrence of a specific event, on the completion of a specific task or project, or at a fixed date other than retirement age. All right? So those will be, you are being employed as an IT technician on this project. Or you are, for example, in the hospitality industry, peak season's coming up, and I'm employing you for 3 months from this date to this date. Those are fixed-term contracts. Is it a fixed-term contract? If it's one of those. If it is, the next question is, do you fall within one of the exemptions? So what are these exemptions? All right, you'll see them on the right. This presumption of permanent employment only applies to individuals who are earning below the BCEA threshold. And what is that? Currently, it is the figure that you'll see on the right-hand side of your screen. So roughly 18,000 Rand per month. Individuals who are earning above that, the presumption doesn't apply to them, even if the other factors are present. Those who are earning below 18,000 per month, they will be presumed to be permanently employed if certain factors are present. All right, so that's the one exemption. The second exemption is you employ less than 10 people, or you employ 50. Sorry, let me just move this stuff. And you've been in operation for less than 2 years. That's the second exemption. And the third exemption is it's either permitted by statute, sectoral determination, or collective agreement. All right. So if one of those exemptions apply, then you don't have to worry about the presumption. All right. If none of those exemptions apply, one moves down to the next question. Is the nature of the work of a limited duration, or is there any other justifiable reason? So if the nature of the work is of a limited duration, for example, this project, then there is an exemption. You can justify it. The other justifiable reasons that our legislation recognizes are those appearing in the block at the bottom right of your screen. So you are replacing someone who's temporarily absent. All right. So maybe someone who's on maternity leave, or someone who's sick, or someone who's on sabbatical, or there's a temporary increase in work that isn't expected to last for more than 12 months. It's a student or a recent graduate gaining work experience. The individual is employed specifically to work exclusively on a specific project or for a limited defined duration. It's a non-citizen and they're there on a work permit. They're employed to perform seasonal work that you'll see often in the agricultural industry. They're employed on an official public work or public job creation scheme. The position's funded by an external source, or they've reached you've reached agreement or normal retirement age. So the normal retirement age of your business or your agreed retirement age, you can then employ individuals on fixed term contracts after that, and you'll be exempted from this. All right. If these exemptions, none of these exemptions apply. So if none of the, if you earning less or than the threshold, or one of these 9 items don't apply to you, then a contract that is concluded or renewed in excess of 3 months is deemed to be permanent. All right. So if you've got someone and you've rolled their 1 month contract 3 times, they are now deemed to be permanently employed on the 4th roll. Or if the contract is 4 months, they will be deemed to be permanently employed if they earn less than 18,000 Rand per month. But one of the other exemptions may apply. So they may be employed for 4 months, they may be earning less than 18,000 Rand per month, but they're employed to replace someone who's temporarily absent, someone who's on maternity leave. Then their employment will not be deemed, they will not be deemed to be permanently employed. So it's quite a complicated process to go through to determine whether or not they're presumed to be permanent employees. However, this little schematic should be able to assist you in working through it. Really, the most important things are what are they earning and what is the reason for their employment. You know, and that boils down to, once again, what is the reason for their fixed term employment? It's always been the case. Why am I employing this person for a fixed period? Is it justified? I know there are a lot of individuals who are using fixed term contracts as probation periods. This speaks to you, because if the individual is earning less than 18,000 per month, then it informs how long the probation period should be before they are presumed to be permanently employed. All right. Bear in mind also that this does not override our existing law about expectation of renewal. So where there is a reasonable expectation of renewal for individuals earning above the threshold, that reasonable expectation still applies. So if there's a reasonable expectation of renewal, or there's a reasonable expectation of permanent employment and it's not given, that is tantamount to a dismissal. All right? Why is this important? This whole schematic is important so that you know that if someone is now deemed to be permanently employed, I have to follow the dismissal processes that we've just discussed, as opposed to just enforcing the contract and saying, right, this is the end of your contract, goodbye. All right. So for those of you employing fixed-term employees, just something to remember. Okay. All right. Sorry, I'm stuffing around with the slides here. All right. Equal pay for work of equal value. We're seeing a lot of this. It's a huge issue at the moment, and the CCMA is inundated with questions about this. All right, and it's a fairly complicated topic, but it's something I'm going to take you through, and the slides speak for themselves. I've made quite detailed notes on this, so when you get the slides, you will have this. Okay, so it came through with the most recent amendments to the Employment Equity Act, and it looks at differing terms and conditions of employment between employees of the same employer performing the same or substantially the same work, or work of equal value that is, all right, so that is important to remember. Same employer performing the same or substantially the same work, all right? And it goes on to say that where there's a difference in those circumstances, and it's directly or indirectly based on any more of the grounds listed in Section 6.1 of the Employment Equity Act, it's regarded as unfair discrimination. So we all know Section 6.1, race, gender, sex, pregnancy, all of those. So if the employee can show that there's a difference in terms and conditions between them and someone else who's of the same employer performing the same or substantially same work, and that distinction is based on one of those listed grounds, it is unfair discrimination. It's not enough to say, oh, we're earning different salaries, so it's unfair discrimination. No, they have to show that the reason for earning, the distinction in earnings, is one of those grounds, and they have to show that it's the same or substantially the same work that they are performing. All right. So, something to remember is where the employee alleges the discrimination is on a listed ground, the employer must prove on a balance of probabilities that the discrimination did not take place or is rational and justifiable. All right? It's important. So where the employee says it is one of those listed grounds, you as the employer then have to prove on a balance of probabilities that no, that is not the case, or that yes, it is the case, but there's a reason, a justifiable reason for it. Okay? Where the employee alleges that it is on an arbitrary ground, then the onus is on the employee to prove on a balance of probabilities that the conduct complained of is not rational, that it amounts to discrimination, and that the discrimination is unfair. Okay, so that's important because often one gets a referral form and it says, okay, this is the situation, I'm being unfairly discriminated against, and what is the reason? Well, bear in mind, if the reason is a listed ground, then you as the employer bear the onus. Where they say it's an arbitrary ground, which is often the case because employees often just refer disputes and they don't actually think them through, and they just say, well, it's discrimination, and they believe that just because there's a differentiation, it's unfair discrimination. But where the employee alleges that it's on an arbitrary ground, the onus is on the employee to prove those items in order for them to be successful with their claim. All right. And you, as the employer, can justify a distinction in certain circumstances. And these are the ones that are recognized in the legislation. So you can have individuals performing work that's similar, but their terms and conditions may differ because of seniority or length of service, because of their qualifications, abilities, competence, or potential above the minimum acceptable levels required for performance. Their respective performance, quantity, or quality of work, provided that the employees are equally subject to the employer's performance evaluation system and that it is consistently applied. Sorry, I'm just having a problem with my slides here. And where the employee is demoted as a result of organizational restructuring, without a reduction in pay, and fixing the employee's salary at that level, that is not unfair discrimination. When an individual is employed temporarily in a position for purposes of gaining experience or training, and as a result receives different remuneration, that is not unfair. Where there's a shortage of skill or any other relevant factor that is not falling in with those listed grounds under 6.1. Those are all justifiable reasons for distinguishing between salaries. All right. So we, as I said, we're seeing a lot of these referrals. The CCMA is inundated with these referrals. There's an upscale on the upscale of these referrals, so you may, as an employer, actually see these coming through. All right. So just remember, if you do see it, don't be alarmed. What are they? On what are the grounds that they're alleging? Is there actually a differentiation? What are the grounds? Is it arbitrary? Is it listed? Then you will know what you need to prove and disprove. And there are certain instances where a difference in salary or terms and conditions is justifiable. All right. Compliance orders, just very quickly, I wanted to touch on this because this is something we're also seeing quite a bit coming up. So as you may know, and And Shane, I wonder if you could just run our second last poll here, is just to see whether anyone has been subjected to a labour inspection in the last 12 months.
There we go. Right, the results of the third poll there. Has there been an inspection by the Department of Labour at your workplace in the last 12 months? It was neck and neck, as I say. We finished off on 53%, very slight majority. 53% have selected no, 47% yes. Back to you, Justine. Thanks.
Okay. That's very interesting. I must say, it seems like the Department of Labour slowed down a bit. Maybe it's as the year's tapering off, but they have been quite active. All right, so this I just wanted to alert everyone to, because we are seeing this, and the process has changed significantly. So those of you who have experienced labour inspections, you'll recall previously the inspector would come around, give you a written undertaking which you would sign saying, I'll comply, I'll fix up the problems. The inspector would come back, and only if you hadn't complied or fixed up those problems, you would then be issued with a compliance letter, and then the Department of Labour would have to apply to the Labour Court to have that compliance document be made an order of court against you, and only then would anything really be done. And it was a lengthy process. It has changed significantly, and I just want employers to be aware of that. This process now applies to any contraventions of the BCEA, the UIF, and the Minimum Wage Act, first of all. So if an inspector comes around and they're now issuing you with a compliance order, all right, and you must either comply with the period specified in that order, or as an employer, believe it or not, you need to refer a dispute to the CCMA. And referring that dispute is on the same LRA 711 referral form that employees use to refer disputes against you. And you have to refer that dispute within the specified period in that compliance order for you to comply. All right? Very important. Because if you do not comply, or you do not refer a dispute to the CCMA, the Director General then applies to the CCMA to have that compliance order made an arbitration award. All right? And that process in the CCMA has been significantly simplified, and now it's a speedy process. So what happens now, as you may know, is that arbitration awards now have the same binding effect as an order of the Labour Court, an arbitration award. So what will happen is the Labour Inspector will come around, issue you with a compliance order. If you do not comply and submit proof of compliance, or if you do not refer a dispute, they simply refer that to the CCMA. A commissioner makes it an arbitration award. That arbitration award then has the power, the same standing as a Labour Court order, and they can either come and attach and remove property to cover judgment if you owe money, or they can institute contempt proceedings against you in the Labour Court. So it allows for much easier enforcement for the Department of Labour, but as you know, sometimes those Labour inspectors don't want to listen to reason. We've had a case recently with one of our clients who that happened to. So it is something to bear in mind and be very aware of, because it's something that can be avoided quite easily. All right, so if that compliance order is issued, you need to either comply, or if there's been a misunderstanding, or if you object to it having been issued, you need to refer a dispute to the CCMA, so that you then part of the process, so that when the matter is set down, you can then go with the assistance of a commissioner and explain your side of the story. All right, so very important to bear in mind. All right, last topic, and Shane, our final poll, if you wouldn't mind running that for me, I'd be very curious to know in the various workplaces if there is maternity leave that is paid or unpaid that is granted to individuals.
Okay, results of that fourth poll. Does your employer or business provide paid maternity leave, or is it unpaid? For this one, we've got 60% as the majority have selected unpaid, and 40% paid.
Wow. 40% is high because the law requires the minimum is unpaid. So you're not entitled to payment. So 40% of businesses, well, 40% are getting paid maternity leave. That's great. That really is. Even though it is only 40%, but it's much higher than I expected. All right, so that leads into our final topic, which is parental leave. And a lot has been made of this in the news, and because it's now paternity leave, leave for fathers now when children are born, which is obviously in addition to your family responsibility leave. That still applies, because remember, that's also for sickness and death. So that still applies. This is in addition to it. All right. And it's called parental leave because it's not just for fathers. Something to remember for business owners is that the effective date has not yet been announced. So while the legislation is in effect and it's been passed, it hasn't been made effective yet. And we're told one of the reasons is because UIF hasn't got its act together and it doesn't know how to process these claims that are going to be coming in. Because this is also unpaid leave. As with maternity leave, parental leave is unpaid leave. Something to bear in mind. So the effective date has not yet been announced. So for employers, where your employees are coming to demand it from you, you need not give it if you do not want it because it's not enforced yet. All right. So what is it? All right. So it's divided between parental leave, adoption leave, and surrogacy. All right. So for parental leave, you are entitled to at least 10 consecutive days leave upon birth, an adoption order being granted, or a child being placed in the care of the prospective adoptive parent by a competent court. In those instances, the individual is entitled to 10 consecutive days leave. So, for example, the father would then be entitled to 10 consecutive days leave in addition to the 3 days family responsibility leave, which is paid still, remember. Okay, adoption leave. The adoptive parent of a child who is below the age of 2 can take at least 10 consecutive weeks adoption leave or parental leave upon the adoption order being granted or the child being placed in the care of the prospective adoptive parent by a competent court. So remember, more often than not, there are going to be 2 parents, and one parent will then be entitled to take the adoption leave, and the other parent would then be entitled to take the parental leave. They cannot both take the adoption leave. All right? So it's either 10 consecutive days or 10 consecutive weeks. Okay. Then we have commissioning parental leave. So this is a commissioning parent in a surrogate motherhood agreement is entitled to at least 10 consecutive weeks commissioning parental leave or parental leave. All right, so where there's a surrogacy arrangement and someone else is carrying the child, the one parent is entitled to 10 consecutive weeks commissioning parental leave, and the other parent will be entitled to parental leave, not both at the same time. So for those of you who've picked up on this, this would apply to same-sex couples as well, which is hugely encouraging. And finally, everything's coming in line with what our Constitution has always wanted it to be. But it can get a bit confusing for employers because now you don't just have to think of paternity and maternity, but this broader spectrum. And we've got some little drawings to assist with that. But before we get to those and finish off, it is unpaid. So you would be claiming UIF for these periods. All right, which is why I wanted to know what maternity leave is like. Because the question then becomes, well, if you're giving paid maternity leave, do you have to give paid parental leave as well? Something to consider, and maybe speak to your HR or your employment law advisors. To conclude, you have to apply for the UIF within 12 months of the birth of the child or the adoption, and the individual has to have been employed for a minimum of 13 weeks prior to applying. All right, so just to break that down for where it is same-sex couples, because one's still getting one's head around all of these things now, but now that it is finally being recognized, where there are two women and one woman actually bears the child, the pregnant woman would be entitled to maternity leave, and the other woman would be entitled to paternity or parental leave. All right. Let's move on to the next slide here. Okay, so where there are two women with neither of them bearing the child, one who's registered as adoptive or commissioning parent would be entitled to 10 weeks paternity leave or parental leave, and the other 10 days parental leave. Because maternity leave wouldn't be fit into that because no one's bearing the child. Where there are two men, obviously no one can bear the child, so the one partner would be registered as the adoptive or commissioning parent would be entitled to 10 weeks paternal leave, and the other 10 days paternity leave. It's like a little bit of a puzzle here. All right. For where we have a man and a woman, with the woman bearing the child, she's obviously entitled to maternity leave, and the partner would be entitled to paternity leave, parental leave. And where we have a man and a woman, the parent, neither of them bearing, the parent registered as adoptive or commissioning parent would be entitled to the 10 weeks, and the other parent the 10 days paternity leave. So a little bit of a change, different. And employers need to now consider and start thinking about putting policies in place, putting payment schemes in place if you're going to be giving these days as paid or not. And just firming up on this, there's an opportunity to do so before this actually becomes effective. All right, and that concludes my session today. I hope it's been informative. Ask, can your method of selection criteria be different per department? It could be different per department. It would be tricky to do so, particularly if you're consulting with a union, because that's something that they would object to. But you would need a good reason for being able to do that. So, for example, if there's a specific skill set that you would require in a department, where LIFO maybe won't comply, then one could look at doing that. But I would definitely, if that is something that you're looking at, I would definitely speak to someone about it, because it is potentially a risky situation. Nothing's impossible, but there is some risk associated with that. So I would sit down with someone and say, look, this is why we're wanting to do it, and get some specialist advice on that. Suzanne, for mutual termination, please ask what reason would be marked on the UI-19 form. I would mark contract ended. That's what we recommend, not resignation, because then the individual will not be able to claim UIF. And we're finding more and more that not being able to claim UIF is a huge issue, and sometimes even results in disputes being referred to the CCMA. So contract ended, that is what I would mark. From Rickus, SARS requirements for someone to be deemed permanent is determined by the dominance impression test, and the importance to separate SARS and labor law. That is completely correct. There's huge confusion between permanent employment and not for tax purposes and for employment law purposes. They are, please understand, separate and distinct. Also, employment in an independent contract for SARS and tax purposes, also the test is different, and there's certain nuances there. So something to remember is also to get advice in those instances. Razan asks, is it fair to dismiss someone if they refuse to come into the office for a disciplinary hearing? Razan, I wouldn't dismiss them for not coming into the office for the hearing. I would hold the hearing in their absence and dismiss them based on the evidence that you are presenting of the misconduct. That is what I would do. That is the safest and the easiest way to deal with it, to not dismiss them for refusing to come in. It's their responsibility to be there. And Desiree asks, how do you determine equal value contribution? I would imagine that's the equal pay, equal work question. There is a regulation that accompanies that Employment Equity Act, they've actually got a detailed schematic which sets out how one goes about determining the contributions of the individuals and how one measures that. So that would be a regulation to the Employment Equity Act, Desiree, and you can go and look at that for further information. Thank you very much.